Is there a limit to how many questions the defense attorneys can ask you at the time of your pretrial deposition? You want to know the answer? Come join me as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is there is no set definable number of questions that the defense attorneys can ask during the course of your pretrial deposition. Now, first of all, what is a deposition? You should know that a deposition is nothing more than a question and answer session that's given under oath in our office, in our conference room. There's no judge there. There's no jury there. Instead, you have the defense attorneys, you have myself, and there will be a court stenographer there. We call them a court reporter, to record all of the questions that you are asked and all of the answers that you are given. Hey guys. Hi Bentley. Hi Daisy. I'm shooting some video. You want to join me? Come here. Come up here and say hello. Oh, this is Bentley. Say hello, Bentley. Hi. And you, Daisy, you want to say hello too? Come here. This is Daisy. Oh yes, Daisy and Bentley are having fun running around the house. Mwah. Okay, here we go. So in this deposition, there's no judge there, there's no jury there, there's simply a court stenographer there. We also call them a court reporter to record all of the questions that you were asked and all of the answers that you gave. Now, I asked the question in the title of this video, is there a certain number of questions that they can ask? The answer is no. In all likelihood, they're going to be sitting in our conference room asking you questions for many, many hours, oftentimes the entire day. Now you might be thinking, wait a second, how is that possible? You didn't have that much medical care and treatment with the doctors whom you have sued. Well, the attorneys who represent the various doctors whom you have sued have an opportunity to learn from you exactly what happened. During this pretrial question and answer session, they are going to learn from you a lot about your medical history. They're going to learn about your surgical history. They're going to learn about who you live with, your demographics. They're going to learn about whether you had any similar problems. And importantly, they're going to ask you about the events that transpired that led you up to the point where you now brought a lawsuit against these doctors. They want to know the details. You should know something else. They are working off of the same medical records that we have worked off of. The only difference is they've not had an opportunity to ask you questions about it like we have. Alternatively, they have had a chance to talk to their own clients, the doctors whom you have sued, so they do have certain information about what occurred. But I'll tell you what they don't have. They don't have details about any conversations you had with the doctor or with hospital staff. They don't have details about how your injuries have affected you on a daily basis. They don't have details about how your injuries have affected you and your spouse or your kids and those things that you are no longer able to do that you were able to do before. They don't have all those details. They have the allegations that we have made, and they have the injuries that we claim you suffered because of the doctor's carelessness. But they need to fill in the blanks, and they need to learn from you exactly what happened. If you brought a claim for lost earnings, for example, they need to ask you about your work history. What type of work did you do? How much were you earning? What is it that you can no longer do today because of this injury that prevents you from working? And how much income do you think you have lost up until today? So is there a limit as to the number of questions they can ask you? I wish there were, but the reality is no, which means that we will likely be there for many, many hours, depending upon how much treatment you received, what actually occurred to you, and what you actually remember. Because if you don't remember a lot of the details, then obviously the length of time they ask you questions will be shorter. But if you have a good memory, if you have knowledge of exactly what happened, then the attorneys will take their time and ask you a great deal of information about the details that occurred, any doctors you have seen since then, how your progress is now, what problems you can expect into the future. And all of these things are geared to learning more details about exactly what happened to you and why. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet brought a lawsuit but are thinking of doing so, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.